She said she owned my courtroom. She had no idea what was coming. In 30 years on this bench, I have heard a lot of opening lines, excuses, justifications, carefully rehearsed stories designed to sound more credible than they are. I have heard people cry convincingly and lie convincingly and do both at the same time. But the morning a woman in a white blazer and diamond earrings looked across my courtroom and said, with a smile so comfortable it clearly came from a lifetime of practice, "People like me don't lose in rooms like this," I felt something I rarely feel during a session. Not anger, curiosity. Because the people who walk in most certain of the outcome are almost always the ones who haven't read the file carefully enough. I had read the file very carefully. I want to tell you about Dana Reyes. She is the reason this story matters. Not the woman in the diamonds, who will get her portion of the telling, but Dana, a 37-year-old single mother who built an event planning business from a second-hand laptop at her kitchen table, who spent 6 months being told she was lying about something she knew was true, who sold her car to pay a lawyer she shouldn't have needed. She sat across from one of the wealthiest women in that courtroom that morning with a worn folder of documents and the kind of quiet dignity that doesn't require jewelry. By the time the afternoon was over, the room understood which of them actually had something worth keeping. If stories like this matter to you, subscribe, because every week I sit down and tell you the truth about what I've seen in 3 decades on this bench. The cases that reminded me why the law is supposed to be the one place where your last name stops mattering. This was one of those cases. Dana Reyes had started her business the way most real things start, not with an investor or a business plan or a family connection. With a borrowed folding table, a printer she shared with her neighbor, and a genuine talent for making events feel like something people would remember. She had worked for a decade as an events coordinator for a hotel, learning every part of the industry from setup to breakdown, from vendor negotiations to the specific art of managing a difficult client without letting them feel managed. When she left to start her own company, she took nothing except what she had learned. Her first 2 years were lean. She took every booking she could find, from children's birthday parties to retirement celebrations to small corporate retreats. She built a reputation the honest way, one satisfied client at a time, one referral passed on at dinner, one review left by someone who remembered how the evening felt. By her 3rd year, she had 2 part-time employees and a client list long enough to feel like stability. Then she got the call from Christina Vale. Christina was the daughter of a Manhattan real estate developer, the kind of wealthy you could measure in the size of the staff that answered her phones. She had organized a charity gala every year for the past 8 years, always lavish, always photographed, always covered by the kind of publications that trade in beautiful rooms and prominent names. Her foundation raised money for children's literacy programs, a cause that looked generous in print. She wanted Dana to plan the gala. Dana said yes. For 3 months, she worked on nothing else. She negotiated with 4 different vendors. She coordinated with a hotel events team, a florist, a catering company, and a lighting designer. She managed a guest list of 240 people. She handled every detail, from the printed programs to the temperature of the room. The evening was, by every account, flawless. Photographs appeared in 2 publications the following week. Christina was quoted praising the event's elegance. Her name appeared 12 times in the coverage. Dana's company was mentioned once in a caption. The invoice Dana submitted came to $18,000. Christina did not pay it. At first, Dana treated it as a delay. She sent a polite follow-up at 30 days, then another at 45. She called the main office and was told that invoices were processed by the accounting team. She emailed the accounting contact provided and received no response. At 60 days, she sent a formal demand letter through her own attorney. This cost her money she had planned to use for payroll. The response from Christina's legal team was a brief email stating that the invoice was under review and that Dana should not contact Christina directly. At 90 days, Dana wrote a single post on her business's social media account. It said, in full, "Our company has not received payment for services rendered at the Vail Foundation Gala in November. We provided full professional services as contracted. The invoice remains unpaid at 90 days. That post had 64 words. Christina's legal team filed a $250,000 defamation lawsuit within the week. The lawsuit claimed that Dana's post had damaged Christina's reputation, disrupted her charitable work, and caused emotional distress. It demanded the post be removed, that Dana issue a public apology, and that she pay damages for the harm done to a respected philanthropist. Dana did not remove the post. She had 2 children at home, a mortgage, and a business that was already losing clients because of the lawsuit's publicity. She had every practical reason to apologize and disappear. She did not, because the post was true. Every word of it was true. And Dana had decided, in the quiet of her kitchen, at 11 o'clock at night, that there was a point past which she would not go. She retained a lawyer on a payment plan. She sold her car and took the bus. And she filed a counter-complaint for the original unpaid invoice. That is how they ended up in my courtroom. Christina Vail arrived with the confidence of someone who has never lost anything she didn't choose to give away. She was dressed in a way that communicated money without having to announce it. Everything precisely calibrated. Her attorney was expensive in a way you could tell from the briefcase alone. She looked around the courtroom as she settled in, not nervously, assessingly, the way people look at rooms they're deciding whether to bother remembering. Dana arrived a few minutes later. She was dressed simply and well. She had a folder. She sat down, organized her papers, and looked at the bench. Not at Christina, at the bench. That small distinction told me something. Dana was here to make her case. Christina was here to win a performance. I called the session to order and asked Christina to present her claim. She spoke fluently. She described Dana's post as a deliberate attack on her character. She said Dana had used her name to generate publicity for a failing business. She described herself as a dedicated philanthropist whose charitable work had been undermined by a disgruntled vendor. She said the payment had been made in full, in cash, the night of the event. She said all of this with the smooth assurance of someone who has been told her whole life that her version of events is the version that counts. I listened without interrupting. When she finished, I asked her one question. Ms. Vail, you said payment was made in cash the night of the event. Do you have a receipt? She smiled slightly. My assistant manages those details. I don't personally track cash payments. Your assistant made the payment.
On my behalf, yes.
Was your assistant present when the payment was given to Ms. Reyes?
I would assume so.
You would assume. She handles these things.
I nodded slowly.
We'll come back to that. I want to tell you what I had already found before that morning. My staff had requested records from Christina's accounts as part of the pretrial process. This is standard in financial disputes. The records showed the account activity for the relevant period, including the week of the gala. There was a cash withdrawal from Christina's account. It was for the correct amount. It was made at 10:53 in the morning, the day after the gala. That discrepancy is small enough that an inattentive judge might have missed it. Christina said payment was made the night of the event. The withdrawal happened the following morning. I also had an email sent from Christina to her assistant at 8:17 that same morning. The email said, "Make the withdrawal today and mark it as last night. I don't want delays." People often believe that deleted emails are gone. They are not always gone. Christina's legal team had produced a portion of the email record as part of discovery. They had evidently not reviewed it as carefully as they should have. I had reviewed all of it. I waited until Christina had finished establishing her version of events before I introduced what I had, because the most effective way to address a lie is not to challenge it the moment it's spoken. It is to let it stand long enough for the person to commit to it fully and then show them what was standing behind it the whole time. Miss Vale, I said, you've told this court that payment was made in cash the night of the event. That's correct. Your assistant handled it. Yes. And the cash was withdrawn from your account in advance of the event. She didn't hesitate. Yes, we keep cash on hand for event expenses. I turned a page. That's interesting, because according to your bank records, the withdrawal in the amount of $18,000 was made at 10:53 in the morning on the day after the gala. A brief pause. Not long, but present. There may have been a previous withdrawal I'm not aware of. Your records don't show one. I have multiple accounts. We requested records from all of them. She looked at her attorney. Her attorney kept his eyes on the bench. Miss Vale, I also have an email sent from your account to your assistant at 8:17 on the morning after the gala. Would you like me to read it into the record, or would you prefer to describe it yourself? The composure did not shatter. I want to be accurate about that. Christina Vale was skilled. She had spent her entire life in rooms where her version of reality was the one that prevailed. And that kind of experience builds a particular type of resilience. But something shifted, something small and irreversible. She looked at me, and for the first time that morning, she was not looking at an obstacle to be managed. She was looking at a problem she had not anticipated. I don't recall the specific contents of every email, she said carefully. That's understandable, I said. Fortunately, we have them. I read the email into the record. The courtroom was very quiet. Dana, across the room, sat absolutely still. She had not known about the email. Nobody had told her. She was hearing it for the first time in the same room as everyone else. She kept her hands folded on the table. She did not look at Christina. She looked at me, and I saw in her expression something I recognized. The careful, suspended hope of a person who has been told for months that their experience wasn't real, now watching the evidence of its reality being spoken out loud. The assistant's testimony came next. She was a young woman named Priya, 26 years old, and she was clearly frightened. She had worked for Christina for 2 years. She had received the email. She had done what it asked. She told me what she had been instructed to do. She told me that she had raised a concern about it. She told me what Christina had said in response. She did not want to be there, but she told the truth. I have a great deal of respect for people who tell the truth when it is costly to do so. It is easy to be honest when honesty is convenient. Honesty under pressure is a different thing entirely. When Priya finished, Christina's attorney requested a brief recess. I granted 3 minutes. When we resumed, Christina's attorney indicated that his client wished to address the court. Christina spoke briefly. Her voice was quieter than it had been. The performance quality was gone. What remained was something more stripped down, a person calculating in real time what the least damaging path forward looked like. She said there had been a miscommunication about the timing of the payment. She said she regretted any confusion. She did not say she was sorry. I noted that. The ruling was not complicated once the evidence was complete. Dana was awarded the full $18,000 for the unpaid invoice, plus legal costs she had incurred in defending against the defamation suit. Christina's defamation claim was dismissed. Dana's statement had been factual. An unpaid invoice at 90 days is an unpaid invoice at 90 days. That is not defamation. That is accurate business record-keeping made public. Additionally, I referred the matter of the altered payment timeline and the instruction to falsify records to the appropriate authorities for further review. That referral is not a conviction. It is the proper process. What happens next is not in my hands, but the referral is made. When I finished the ruling, I looked at Christina. I want to say something to you that goes beyond the legal decision. She met my eyes. Her expression was controlled. She had composed herself back into something that looked like dignity. You are a person with significant resources, I said. You have a foundation with your name on it that raises money for children's literacy. You have influence and connections and access that most people in this country will never have. And you used some portion of that to pursue a $250,000 lawsuit against a woman who owed you nothing and whom you owed $18,000. I let that sit for a moment. I don't know why people with the most choose to fight hardest against those with the least. I've been trying to understand it for 30 years. I still don't have a satisfying answer. But I know what it costs. Not to you, to her children, to the nights she spent at a kitchen table trying to understand how doing her job correctly had become something she had to defend. No amount of money makes that cost acceptable. I brought down the gavel. Dana did not celebrate loudly. She sat for a moment after the ruling, with her hands still folded on the table, as though her body needed a moment to catch up to what had just happened. Then she exhaled, long and quiet. The exhale of someone who has been holding something for a very long time and has finally been told they can put it down. Her attorney leaned over and said something. She nodded. She gathered her folder with the same careful movements she had used when she arrived. As she stood, she looked across the room once, briefly, at Christina. Not with triumph, not with anger, with something harder to name. The look of a person who has been in a long, exhausting fight and is simply glad it's over. She walked out of that courtroom with her dignity and an $18,000 judgment, and the story of a woman who had kept her word when it cost her nearly everything. The clip circulated as these things do now. What people focused on, I was told, was not the evidence or the ruling. It was the moment during the email reading when the camera caught Dana's face. Just for a second, the stillness of her, the held breath, the quiet that comes just before something you have waited a long time to hear is finally confirmed. Viewers said it looked like relief. It was relief. Dana's business recovered. It took time and it took work, but it recovered. She was invited to speak at a small business association conference about persistence. She said, characteristically, that she wasn't sure she had done anything exceptional. She had just refused to say something false. She didn't understand why that required explanation. That line, plain as it was shared more widely than anything else she said. I want to close with something I have thought about often since that case. There is a particular assumption that money makes. It assumes that having more means knowing more, deserving more, mattering more. It assumes that the systems built to distribute justice can be navigated the same way other systems can, through connections and influence and the sheer weight of being important. Sometimes, I will be honest with you, that assumption is correct. Not in my courtroom, but in the world. Systems fail. People with power walk away from things they should not have walked away from, but not always. And the reason not always is people like Dana, people who refuse to say the false thing even when the false thing would end the pain, people who organize their documents carefully and tell the truth steadily and trust, not naively but determinedly, that the truth will eventually matter to someone. It is not a guarantee. I cannot promise you that every Dana wins. I have seen enough to know better than that. What I can tell you is that the Danas are the reason the system is worth defending. They are the reason I have spent 30 years trying to get it right. They walk in with worn folders and they tell the truth, and they sit quietly while someone with a more expensive attorney tries to make the truth sound like a lie. And sometimes, on a good day, the truth holds. When it does, it is not a small thing. It is everything the law is supposed to be. Share this story with someone who needs to hear it, because somewhere right now, there is a person sitting at a kitchen table trying to decide whether the truth is worth fighting for. Tell them it is.